Hello, everybody.
Court calls a matter of people of the state of Michigan versus Christopher James Dennis Kamen. This is file 24-5335 on page.
You're talking behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Christopher Kamen.
Thank you, sir. Are you Christopher James Dennis Kamen?
Yes, sir.
Mr. Kamen, we're here today for a status conference and a plea cutoff. We have a trial for your benefit set right now on April 30th and May 1st. You're aware of that background, correct?
Yes, sir.
And have you maintained good contact with your attorney since the last time we were in court in about December of 2024?
Yes, sir.
Mr. Thompson, what can you tell me regarding the readiness of this case for trial and how we should otherwise be proceeding?
Well, Your Honor, I have spent a lot of time with Mr. Kamen the past week. He's been seriously considering the plea offer, which is an offer to an attempt. He's charged with a 5-year felony, possession of a firearm by a felon. The offer would be an attempt to make it a 2.5 year. I just asked the court to ask Mr. Kamen about his intentions.
First, is that an accurate statement of the plea offer, Ms. Coe?
It is, Your Honor.
Mr. Kamen, were you aware of the terms of that plea offer?
Yes, sir. Mr. Thompson explained most of the conditions to me.
And so is it fair for me to understand that you're aware of the benefits of the plea as well as the risks of the plea?
I'm not, well, yeah, pretty much, because the risks of the plea will be to max sentence, correct?
Well, under the plea agreement, right now you're charged with possessing a firearm while you were prohibited to do so because of the prior felony conviction. That means it's a felony that has a maximum of up to 5 years in the state prison system. But if you plead guilty under the plea offer to an attempt by law cuts the maximum penalty in half. Then the maximum penalty would be 2.5 years maximum that you could ever face. You understand that benefit of the plea agreement?
Yes, sir.
And did you have time to talk about it with Mr. Thompson?
Yeah, shortly, but enough.
All right. And so we have a trial set for you on April 30th and May 1st. And as I explained to you previously, what I do when I set a trial is also set a plea cutoff in advance of trial. And the reason I do that is I don't want to keep cases on for trial if we don't need them. If we need a trial, then you'll have it. You have a constitutional right to a jury trial. So the question becomes at a final status conference and plea cutoff, whether or not you want to keep the trial on so the jury can determine the issues, or whether or not you want to take advantage of the plea offer. And it does not matter to me what you do. I just need to know what you're deciding so that I can schedule appropriately. So which option would you want to have? Did you want to take advantage of a plea offer, or did you want to have a jury determine the case?
At this moment in time, with me being able to think about it, I'm pretty confident in just accepting the plea.
In other words, you don't want to have a trial and you'd prefer to take advantage of the plea offer that's been stated on the record today. Is that right?
Yes, sir.
Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, sir.
So again, Mr. Kamen, under this plea agreement, you're going to be pleading guilty to the offense of attempted possession of a firearm by a felon. Do you understand that?
Yes, sir.
And the prosecutor would then dismiss the charged offense. That makes it a 2.5 year maximum offense instead of the originally charged 5-year maximum. Do you understand that?
Yes, sir.
If you're convicted of the attempt, the law also requires mandatory forfeiture of the weapon or device. Do you understand that?
Yes, sir.
And understanding the benefit of the plea agreement as well as the maximum penalty associated with that plea, then how do you plead to the attempt?
Guilty, I believe.
If you plead guilty, did you have a question about your plea, Mr. Kamen?
No, my brain's been jambled with this whole case and everything going on lately between the
That's
move.
all right. I'll try to go through it slowly. If you have questions about the procedure during, you can let me know, raise your hand, get my attention, and we'll make sure we go through it so that you understand. You need to understand that if you enter a guilty plea, you no longer will have any automatic right to appeal. If you're convicted following a jury trial, you have an automatic right to appeal. But if you're convicted by a plea, you have limited appeal rights. You would have to instead ask for what's called leave to appeal to the Michigan Court of Appeals. Do you understand that?
Yes, sir.
If you plead guilty, you lose all of your current trial rights, including the right to trial itself on April 30th and May 1st. Those rights include the right to be tried by a jury of your peers, the right to be presumed innocent until you're proven guilty, and the right to have the prosecutor bear the burden of proving your guilt beyond a reasonable doubt. At your trial, you'd have a right to have each of the witnesses against you, and you would have the ability to see, hear, and question them. And you would have the right to have the court order any witnesses on your behalf to be ordered to appear at trial. You'd have the right to remain silent at your trial and not have that silence used against you, and you would have the right to testify at trial if you wanted to. But if you enter a guilty plea, you lose those trial rights. Do you understand?
Yes, sir.
And because you're giving up your right to trial itself, you also necessarily give up the right to challenge other things that you might have been able to challenge if you did have a trial. Do you understand that?
Yes, sir.
Outside of the plea agreement, has anyone promised you anything to get you to plead guilty?
No, sir.
Has anyone threatened you in any way to make you feel like you have to plead guilty?
No, sir.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And is it your own choice to plead guilty?
Yes, sir.
The prosecutor claims the offense happened on or about January 12th of 2024. So were you present here in Crawford County on January 12th of 2024?
Yeah, in Crawford County, yes, sir.
All right, and prior to that date, had you been convicted of a felony offense of controlled substance delivery or manufacture of a Schedule 1, 2, or 3 controlled substance?
Yes, sir. My prior charge is the reason why I have the other felony.
Your what?
Is that for the prior charge, the other felony that I have?
Right. Did you have a felony on your record as of January 12th of 2024?
Yes, sir.
And when was that felony committed? And when was it placed on your record?
I believe in 2019 or 2020.
And then after the conviction in 2019 or 2020 for that felony offense, do you agree you did not take the actions that you needed to regain your ability to possess a weapon here in Michigan?
Yes, I believe so.
And then on January 12th of 2024, and while you were here in Crawford County, did you possess a weapon?
I didn't possess. It was attempted, pretty much, per se.
Well, how do you per se attempt to possess a weapon? And when I say weapon, I mean firearm. How did you attempt to per se possess a weapon?
It was offered to me by somebody at the time, and I turned it down because I knew I had a felony.
So it doesn't sound like you attempted to do anything. It sounds like you attempted to not do anything.
What do you mean by that?
Well, you just told me you turned down a request of somebody to have you get a firearm.
No, that's where it's all misleading. I was not in possession of any sort of firearm.
How would I find you guilty of that attempted offense?
What's that?
Then how would I find you guilty of that attempted offense if you're telling me you're not guilty of it?
Because attempted means that it was attempted. That doesn't mean that it was actually followed through with. It's just an attempt.
This is not a complicated process. If you tell me you're guilty of an attempted crime, you have to tell me that you're guilty of an attempted crime. If you tell me that you're not guilty, that's the reason why we have jury trials, if we need them, because a jury will determine whether, based upon the evidence presented by each side, whether they believe you're guilty. But if you're telling me that you're not guilty, then I'm not going to accept the plea from you.
Okay, well, then at this point, I'm guilty of it.
Well, how are you guilty?
Because there was a firearm involved that I knew about, and it was attempted to be in my possession, I guess.
Where was the firearm at?
It was through somebody. It was through a job that I had done work for people for.
Did you physically have possession of the firearm?
No, sir. I had photos.
I'll know some limited questions by you, but as you can probably sense, this process is not going the way that a plea ought to go, in my estimation. So if you have some additional questions, you can ask of your client that might get to a factual basis, I'll allow it. Otherwise, I'm inclined to just keep the trial on and have the jury determine whether or not there's evidence sufficient to convict or not. So did you have questions for your client?
Mr. Kamen, did you do anything to attempt to possess a firearm?
Not willingly. It was being offered to me and I declined it.
I would agree with the court, Your Honor. This matter should be set for trial.
All right, Mr. Kamen, I reject your plea or your attempt to enter a plea. This matter is best resolved by a jury. So I'm going to keep the jury trial on. Your jury trial is set for April 30th and May 1st of 2025. Just go based on the number of witnesses you're going to call. You still believe you're going to need 2 days?
I mean, how come I can't accept the plea right now?
You can't accept a plea when you tell me you're not guilty, Mr. Kamen. That's not how this process works.
Well, I'm telling you, I'm guilty of it. I did try to acquire it. That's why I'm trying to accept this plea.
Can I ask him a question, Your Honor?
That's not what you told me, Mr. Kamen. This isn't a funny situation, but I laugh in part because it's frustrating to me that as we get past the time when you've told me multiple times that you're not guilty, that now you're telling me you want to enter a plea. That's frustrating to me because this is not, again, a complicated process, and it's one that you've known about for months leading up to today. Ms. Koch, you can ask a question if you think you might get to a factual basis.
Mr. Kamen, you messaged a person named Joe Smith who sent you a photo of a gun, and you wrote back, "Yo, how much? I want that for myself. I got pounds of good green. I can trade. Just let me know." Did you say that?
No, I never once said that.
Okay. Were you trying to purchase that gun from somebody?
No, if the facts are straight, it was trying to be given to me for money that was owed.
The matter is going to be set for trial. If parties can present. Ms. Koch, do you think a day is enough, or do you think it should be safe I should keep 2 days?
I think we can do it in a day.
I have 2 potential witnesses at this time, Your Honor. I'm not committing to calling either one that I would think would take, within 2 hours, just in terms of the trial schedule.
Well, you know the case that the prosecutor's at least going to levy. Do you think the prosecutor's witnesses that you think she's going to call and your witnesses can get that in a day?
That would be my prediction, yes.
Well, I'm going to keep the trial date on for April 30th. May 1st is already set aside as a trial date, so we'll use it if we need it. We'll not use it if we don't, but it'll be on if we need it as a backup date. Mr. Kamen, my requirement for you and for your attorney is that each of you are here and ready to proceed to trials no later than 8:30 on the morning of that trial. That's April 30th. That's here in the circuit courtroom for Crawford County. That's an in-person proceeding, of course. Do you have any questions about that?
No, sir.
Ms. Koch, you otherwise ready to proceed to trial or anything else the court needs to be aware of?
No, we're ready to proceed.
Mr. Thompson, further?
No, nothing further.
We'll see you on your morning of trial, Mr. Kamen. Thank you.
Yep. Bye.
Go on the record in the matter of People's State of Michigan versus Belonga, file 244672 SM and 244796 SM as well. Mr. Belonga, can you hear me?
Yes, I can hear you.
All right, go ahead and state your name. Mr. Wilson, I need you to stop moving around or at least mute yourself because whatever movements you're doing is coming through really loudly.
Kyle Boranchi.
No, Mr. Wilson, yeah, okay. Mr. Belonga, did you state your name? You did.
Yeah, Kyle Boranchi.
All right, very good. Ms. Strasser?
Pastor Strasser, on behalf of Kyle Belonga, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. He's entering a plea of not guilty. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for pre-trial and trial.
All right, we'll indicate a not guilty plea and set the matter for a jury trial, pre-trial. In advance of that, we'll indicate court-appointed attorney has been appointed. In regard to the bond, we will identify bond at for each of the files at $200 personal recognizance.
Thank you, sir.
And sir, you're all set. You can leave the court. If you have any questions, follow the prosecutor's office.
Oh, thank you.
We can proceed with Ms. Bowen.
What? I got to catch up though. There were two of these, so let me get them both done.
There's Mr. William, or Mr. Tarrant.
All right, let's go ahead and do that quick.
Okay.
Well, at least, Mr. Burnett, you need a breakout room?
If I could for a moment, Your Honor.
All right.
Mr. Tarrant will have to, there he is.
Mr. Tarrant, we're going to need to put you into a breakout room with your attorney. We'll be, and as soon as you're done talking to him, we'll bring you right back in and address the competency hearing, okay? So you're going to need to accept the invitation. While they're doing that, Ms. Strasser, what case are we ready to proceed with?
Ms. Bowen.
Let's go on the record in the matter of the people state of Michigan versus Catherine Bowen. Ms. Bowen, can you hear me?
I can.
State your name.
Catherine Bowen.
All right, Ms. Strasser.
Strasser, on behalf of Ms. Bowen, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. She's entering a plea of not guilty. We did conduct a screen for indigency and found she does qualify, so she will be receiving a court-appointed attorney. We request this matter be set for pre-trial and trial.
We'll set the matter for, enter a plea of not guilty, set the matter for a jury trial, pre-trial in advance of that. We'll indicate public defender representation. We'll continue the bond at $500 personal recognizance. Ma'am, you're all set. You can leave the court. If you need to, if you have any questions, you can follow up to the public defender's office. Good luck to you, ma'am.
Thank you.
Sir Ellis, can you hear me?
Yes, I can, sir.
State your name, please.
Matthew Ellis.
This is in regard to file 250189SM and 244885SM. And go ahead, Ms. Strasser.
Ms. Strasser, on behalf of Mr. Ellis, for the limited purpose of arraignment, we have reviewed the charging document and waived formal readings. He's entering two pleas of not guilty. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for pre-trial and trial.
All right. In regard to both of these matters, we'll go ahead and indicate not guilty, set the matter for a jury trial, pre-trial in advance of that. We'll indicate public defender representation on both of these. The bond is $500 personal recognizance on both of these, and the no contact order identified on each file will be continued. In regard to file 244885SM, that will be Zachary Lee Ellis. And then in regard to the other file, 250189SM, we'll indicate not guilty, set the matter for a jury trial, pre-trial in advance of that. There'll be public defender representation. We'll also continue bond on that file at $500 personal recognizance. And we'll also continue the no contact pertaining to Oliver Ellis. Sir, you're all set. You can leave the court. If you have any questions, follow with the public defender's office. All right.
Thank you, Your Honor.
On the record in the matter of the people state of Michigan versus Gould, file 250373SM. Mr. Gould, can you hear me?
Yes, I can, sir.
State your name, please.
Timothy Gould.
Ms. Strasser.
Ms. Strasser, on behalf of Mr. Gould, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. He's entering a plea of not guilty. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for pre-trial and trial.
We'll indicate not guilty, set the matter for a jury trial, pre-trial in advance of that. We'll indicate public defender representation. We'll also continue the bond on this matter, identified at $500 personal recognizance. And also continue the no contact order with Bernita Bixler. And sir, you are all set. You can leave the court. If you have any questions, follow up with the public defender's office. Good luck to you.
All right, thank you, Your Honor.
Ms. Strasser.
We can proceed with Leland Deligan.
On the record, in the matter of the people of the state of Michigan versus Leland Ligon, file 250341FY. Mr. Ligon, would you state your name for the record, please?
Leland Ligon.
All right. And this is, make sure I have the right file here. Okay, very good. Go ahead, Ms. Strasser.
Ms. Strasser, on behalf of Mr. Ligon, for the limited purpose of arraignment, we have reviewed the charging document and waive a formal reading. We did conduct a screen for indigency and found he does qualify, so he will be receiving a court-appointed attorney. Request this matter be set for probable cause and preliminary exam.
All right, the probable cause will be March 13, and the preliminary examination will be March 18. Will indicate public defender representation. Bond on this matter is currently $1,000 surety. We'll continue that. Sir, you're all set. You can leave the court. If you have any questions, follow up with the public defender's office. All right. Good luck to you.
Be safe, be well, sleep sweet, and much love.